start with succession. We'll just take a couple of important points and then we'll continue our discussions tomorrow. There is really nothing to fear when it comes to succession. Okay? Although understandably a lot of law students have a dread, a fear of succession that can be traced to an root cause. The reason why most of us took up law is because we thought that law was the course which had the least amount of mathematics. Okay? A lot of law students simply hate arithmetic and mathematics. Of course, in succession, it cannot be helped. There are, as we go along, we will reach certain parts where we cannot avoid but make some computations. But don't worry. In the bar examinations, you will not be asked to make to make complex mathematical computations. If you will be asked problems involving distribution, I assure you it will just be very simple cases of computation, if at all. Okay. So, the thing is, as long as we remember basic principles, we will be able to solve whatever problem they may be asking in the bar examinations. After all, the chairperson of this year's bar examination assured the law deans that the thrust will be on basics, basic principles. After all, that is what should really be emphasized insofar as examinees are concerned. What are the things which a new lawyer ought to know? So basics. Okay. What are the basic principles? Oh, well, one very important basic principle in succession, of course, is the primacy of the will of the decedent. Okay? So that's one basic underlying principle of our law on succession. Primacy of the will. To a certain extent, that is somehow mitigated by the provisions on legitime. Diba? Kasi, while generally speaking, the testator has the right to give his property to anyone he wants, to do with his property in any way he pleases, to a certain extent, that right is mitigated by the provisions of the law on legitimes. Kung meron kang compulsory heirs, hindi pwede. You cannot simply dispose of your entire estate in favor of anyone whom you pleases or whom you chooses or whom you choose. The law reserves a certain part of your estate for your compulsory heirs. Okay. That's the reason why, as a general proposition, one basic rule in succession is testacy is preferred over intestacy. Okay? Testacy, testate succession, is preferred over intestate succession. This is somehow related to one of the theories as to the basis of succession. There are several theories. Okay. One theory is that succession is simply an extension of the right of ownership. In other words, if you are the owner of property, you should also have the right, not only during your lifetime, but even after you're dead, to determine who will benefit from your properties. Ikaw may-ari nun eh. So dapat may karapatan ka na magdesisyon kung kaninong mapupunta yung properties mo. Okay, so that's one theory. Succession is simply an extension of the right of ownership. Another theory is that succession is based on the right of the family. Okay? The basis is family co-ownership. As we go through life, as we acquire properties, we have our families with us, okay, who helped us amass wealth. So family co-ownership is the basis of succession, according to another theory. Of course, a third theory would try to combine both earlier theories, extension of the right of ownership as well as family co-ownership. All right. But what is succession? The law gives us a caudal definition in Article 774. Succession is a mode of acquisition by virtue of which the property, rights, and transmissible obligations to the extent of the value of the inheritance are transmitted through a person's death to another or others, either by his will or by operation of law. Article 774, if you look at it, already tells us a lot about succession. The law says it is a mode of acquisition. Succession, therefore, by itself, is a separate, distinct mode of acquiring ownership. That being the case, succession is sufficient to transfer and convey and vest ownership in a person. It is itself a mode. Article 774 also says there is a transmission through his death. That tells us another important thing about succession, whether testate or intestate. You only have succession, testate or intestate, if and when there has already been death. That, therefore, is essential for there to be either testate or intestate succession. But what is death? Of course, that's the next logical question. When is a person considered dead? In both medical and philosophical circles, especially abroad, this has been the subject of a lot of debate. When is a person considered dead? Okay. For our purposes, I think we can agree on a basic working concept or idea. A person is considered dead when there has been a total, permanent, irreversible cessation of essential bodily functions. From the point of view of the law, there is no such thing as temporary death. Death is the most permanent thing there can be under the law. If a person, for example, is rushed to the hospital at 7 o'clock in the morning, he has obviously suffered a massive heart attack, rushed to the emergency room of a hospital, no less than 2 different doctors said he is dead. DOA, dead on arrival. And so, after that, the doctor signed the death certificate. He's taken home by his relatives. He is appropriately dressed in the proper attire for the wake, and he's laid out. At 11 o'clock the same morning, he suddenly sits up, asks for a glass of water and some food, which is not an outright impossibility. Okay? I always tell my students, I even read an entire book about these types of experiences. Okay? Remember in the in that play by Shakespeare, yung sa Romeo and Juliet, di ba? One of them was supposed to have taken a potion which would produce effects similar to death. Okay. Ang title ng book is The Romeo Factor. Okay. So it has happened in a lot of cases, many times in the past. This has been documented. The question is, was there succession from 7 o'clock in the morning up to 11 o'clock that same morning when he appeared to be dead? The answer is no. No such thing as temporary death. Okay? You're either dead or not, but no temporary death. Okay. In succession, there are the so-called subjective elements and the objective element. What are the subjective elements? The person who died. Yan ang bida dyan. And those who succeed him. His heirs, legatees, devices. The objective element is the inheritance. And this connection, you remember the most important provision in succession. I refer to Article 777. That's a very useful article. As we go along, you will realize that many other provisions in succession are actually premised on the principle, the rule contained in Article 777. After all, it's one of the shortest provisions in the Civil Code. The rights to the succession are transmitted from the moment of death of the decedent. If a person dies at 7 o'clock in the evening, from that very moment, okay, successional rights are already transmitted. Kahit na sabihin nating medyo mainit-init pa yung kamamatay na tao. Okay? Successional rights are transmitted from the very moment of death. Okay. It is from that moment when there is a transmission of rights. Up to now, one of the best illustrations of this principle is still that old case of Lorenzo versus Posadas. A person died. In that will, in the will which he left, sabi niya, I give all of my properties to my nephew. But he said he will get these properties only after 10 years from the time of my death. In the meantime, the properties would be administered by his executor. The question which arose is this. In determining the amount of taxes due, which should be used as basis? The value of these properties at the time of death or the value of these properties at the end of the 10-year period when they are supposed to be delivered to the heir? Applying what is now Article 777, Supreme Court said, of course, it should be the value at the time of death. Because it is at that moment, at the moment of death, when there is a transmission of successional rights. Of more recent vintage, you have the case of Locsin versus Court of Appeals. In that case, which is quite similar to the case involving the estate of the late Doña Chito Madrigal. Okay? Sa case ni Doña Chito, ang mga survivors are only nephews and nieces. Kasama si Jambi Madrigal. Okay. Who is running for president. All right. Sa Locsin, ganun din. Puro nephews and nieces ang survivors. during the lifetime of the decedent, practically all of the properties were disposed of during the lifetime. So, nung namatay, konting-konti lang natitira sa estate. Ang sabi ng nephews and nieces, teka muna, paano naman kami? Konti lang natira. If those properties had not been disposed of during the lifetime of the decedent, we would have inherited those properties. Correct. The problem is that you have Article 777. The nephews and the nieces are only entitled to such estate as existed at the moment of death of the decedent. Because it is only at that moment when there is a transmission of successional rights. Sorry na lang kayo kung konti na lang ang natira. But I must hasten to add that if the survivors had been compulsory heirs entitled to legitimes, that's an entirely different story. Okay? Otra cosa yan. Because you would then have to go through the process of collation, at least insofar as the gratuitous dispositions are concerned. But in that case of Locsin, wala. Puro ano lang yan. Legal heirs who are not compulsory heirs. Nephews and nieces. Okay. The transmission of rights occurs at the moment of death. For there to be succession, however, it is not always required that you actually see the people, the person lying in estate. Okay? Sometimes, there can be succession even on the basis of presumptive death. Okay, so we should remember what are the situations when a person is presumed dead for purposes of succession. Okay. You have ordinary absence and extraordinary absence. Para ding halo-halo yan. May ordinary at may special. Okay. Ordinary absence. After an absence of 10 years, the absentee is presumed dead even for purposes of succession. Ibig lang sabihin yan, pwede nang paghati-hatian yung kanyang mga naiwang pag-aari. Okay? You remember, however, there is a provision intended for senior citizens. If you disappear after the age of 75, your relatives have to wait for only 5 years. Okay? Para ba sinasabi ng law, pag 75 na yan, nawala yan. Hanggang 5 taon na lang siguro ang tatagal niyan. Okay? Hanggang 80. Which is not really an arbitrary standard. Those of you who are fond of reading sacred scriptures, you will, if you read somewhere in the Psalms, I just cannot remember exactly which psalm is that. Okay? Sabi doon, the ordinary span of human life is 70 years. 70. At pag medyo malakas ka daw sa taas, hanggang 80. Okay? So, it's not really completely arbitrary yung fixing ng yung if the age at disappear at the age of after 75, 5 years lang. That has some biblical foundation. Okay. Extraordinary absence naman. This would involve situations where a person disappears under circumstances where there is great danger or risk of death. Okay. Those on board airplanes or ships which have sunk or disappeared, they have not been they have been absent for 4 years. Those who took part in war, okay, missing in action, MIA, 4 years. those in danger of death under other circumstances. Anong posible ang mga other circumstances niyan? Well, one possible siguro dyan is, halimbawa, merong a mine, merong minero, a miner, tapos nagkameron ng cave-in or what na hindi na makita, that can possibly qualify. All right. When is death deemed to have occurred? So, I repeat, ordinary absence 10 years or 5 years. Presumed dead. But once the presumption has arisen, when is death deemed to have occurred? In the case of ordinary absence, death is deemed to have occurred at the end of the period, whether it's 10 years or 5 years. In the case of extraordinary absence, death is deemed to have occurred at the start. For a good reason. Why? Kasi yung extraordinary absence, there is great danger or possibility of death. Medyo mahirap itong case, whether it's ordinary or extraordinary absence, you have to wait for the period to expire before the presumption would arise. So, halimbawa, ito yun. Okay, 10 years. So, from here to there, that's 10 years. You have to wait for the expiration of the period before the presumption of death would arise. Once you reach the 10th year, he is presumed dead. So, ang tanong is, next question is, when is he deemed to have died? At the end of the period. Okay? In the case of extraordinary absence, again, you have to wait for 4 years to pass before the presumption of death would arise for purposes of succession. Once the 4th year has been reached, the presumption would arise. He is presumed dead. When is he deemed to have died? At the start. Okay? And that's based on common sense. Sabi ko nga halimbawa, merong kaibigan, sumakay ng eroplano, January 1. Okay? The flight is supposed to be from Manila to Davao. Sabihin natin mga 1.5 hours. The plane never landed in Davao. That plane has been missing ever since. Okay? Despite a search conducted throughout the entire length and breadth of our archipelago of more than 7,000 islands, could not be found. So, after 4 years, presumed dead for purposes of succession. Siyempre naman, pag tanong mo, kailan kaya namatay ito? Chances are, same day yan, January 1. of the year when he boarded that plane. Because an airplane cannot remain indefinitely in the air. It will somehow land whether there is an airport or not the moment it runs out of fuel. Okay? It cannot remain indefinitely flying. All right. So, based on elementary human experience and common sense. Okay. Succession may be testate, intestate, or halo-halo, mixed. Okay? Testate, if it's based on a will. Intestate, if there is no will, the will is void, based on the provisions of the law on intestate succession, and it is mixed, halo-halo, if it's partly by will and partly by operation of law. Halimbawa, the testator did not dispose of his entire estate by will. He disposed of only 40% of his properties by will. The rest, yung 60%, walang provision covering them in the will. Then, 60% will be governed by intestate succession, 40% will be governed by his will. So that would be a case of mixed succession. Okay. Tandaan lang natin, wala na ngayon yung contractual succession. There used to be, pero wala na. With the advent of the family code, there is no more contractual succession. Pambihira yan. There used to be, before the family code, under the civil code, there used to be what was called contractual succession. That was under Article 130 of the Civil Code. Yung sabi, the future spouses may, in their marriage settlement, give to each other as much as 1/5 of their present properties, and with respect to future property, only in the event of death to the extent laid down by the provisions of the Code on Succession. Article 130, Civil Code. If you look at the Family Code, there is no provision similar to Article 130. So, nawala na yung contractual succession. Noon, why was that called contractual succession? Because it allowed the future spouses to give to each other properties mortis causa through their marriage settlement. A marriage settlement, of course, is a contract. Yung kapitulasyon matrimonial, that is a contract. And yet, under Article 130 of the Civil Code, the spouses were allowed to give to each other future property mortis causa through their marriage settlement. Kaya ang tawag doon, contractual succession. Wala na ngayon yan. Okay? Ang succession ngayon, testate, intestate, mixed. All right. Remember the distinction between heirs on the one hand and legatees and devices on the other. Okay. Why? Bakit kailangan alam natin yan? Because under certain provisions of the Civil Code on succession, they are treated differently. Sometimes they are treated in the same way. But under certain provisions, they are treated differently. Magkaiba ang trato at magkaibang magkaiba. Okay? So kailangan laging alam natin, is he an heir or is he a legatee or a devicee? Okay. What are some of the provisions where they are treated differently and where the legal consequences would be radically different depending upon whether he is an heir or a legatee? Ang pinaka-importante dyan yung sa preterition under Article 854. Okay? Alam natin ang rule sa preterition. The omission of one, some, or all of the compulsory heirs in the direct line will result in the annulment of the institution of heirs. Under the same provision, however, sabi ng law, legacies and devices will be respected as long as they are not inofficious. So, kung nagkameron ng preterition and you happen to be an heir, patay kang bata ka. You end with 0. Wala kang mahihita. Wala kang mamanahin. Okay? But if you happen to be a mere legatee or devicee, pasalamat ka. Meron ka pa ring makukuha. Okay? Very simple illustration, just to drive home the importance of knowing the distinction. Let us assume that Mr. X has one legitimate child, S, isa ang anak. Okay. He dies with a will. There are only two provisions in his will. Number one, sabi niya, I give my friend F 10,000 pesos. Okay. Number two, I give the rest of my estate to my friend G. Rest of estate. All right. X dies, leaving a total hereditary estate of 120,000 pesos. Okay. With that will. You will notice that S is not mentioned in the will. And let's assume that during the lifetime of X, he had given nothing by way of donation to S. Walang naibigay. All right. So, S is not even mentioned in the will. Ang nakalagay lang sa will, F and G. F, 10,000. G, the rest of the estate. Okay. X dies, leaving 120,000 pesos. How do we distribute the estate? This is a classic case of preterition. Okay? All right. Or, siguro may tanong natin, kung binanggit naman si S, I give S of all of my love and affection. Preterition pa rin yun. Sabi ko sa mga estudyante ko, your love and affection may be nice, but we need cash. Okay. So, preterition. Basta walang binigay. Now, since there is preterition, we now have to apply Article 854. Sabi ko nga kanina, we should know whether you are an heir or a legatee or devisee. In the case of Mr. F, F is obviously a legatee. Legatee. Okay? He's a legatee. Therefore, his legacy under Article 854 will be respected if it is not inofficious. Out of 120,000, the legitimate of S is 60,000. Okay? The other half, yan ang free portion. 60,000. A legacy or a device will be considered inofficious if it exceeds the free portion. In the case of the 10,000 legacy in favor of F, obviously, it can very well be contained in the free portion. Meron pang sobrang 50,000. Okay. Ang tanong natin is, to whom will this 50,000 pesos go? Should it be given to G as provided under the will? Or should it go to S? The answer is, it should go to S. Why? Because under Article 854, once there is preterition, that will result in the annulment of the institution of heirs. The institution of G is annulled. Parang hindi siya na-institute as an heir. Okay? It is as if nobody was instituted as an heir because of the preterition. There is therefore no legal basis for giving G anything at all. He ends up with zero because he happens to be an heir. So when is a person considered an heir? If he's given the entire estate or a fractional or aliquot part of the estate. I give my friend X 1/2 of my estate. X is an heir. I give him 1/4 of my estate. He is an heir. Okay? I give him the rest of my estate. He's an heir. A person, on the other hand, is a legatee if he is given by will a specific or determinate item of personal property. I give my friend A my car. A person is a devisee if he is given a determinate item of real property. I give my friend A my farm in Bulacan. I give A my house and lot in Quezon City. In those cases, the beneficiaries are considered devisees. Okay? All right. So, in case there is preterition, I would rather be a legatee or devisee rather than an heir. Having said that, it does not necessarily follow, however, that it is always better to be a legatee or devisee rather than an heir. Kailan naman, when would it be better to be an heir? In the case of after acquired properties, for example. What are after acquired properties? These are the properties referred to in Article 793 of the Civil Code. Property acquired after the execution of the will and before the death of the testator. Ang tawag dyan, after acquired properties. What is the rule with respect to after acquired properties? Properties acquired after the making of the will shall only pass thereby as if the testator had possessed them at the time he made his will, if it expressly appears upon the face of the will that that was his intention. What is the general rule, therefore, insofar as after acquired properties are concerned? They do not go to the testamentary beneficiary concerned. Exception, if it expressly appears upon the face of the will that the intention of the testator is to give them to the testamentary beneficiary. In the will of Mr. X, he says, I give my friend F all of my cars. At the time he made this will, he had 5 cars. Later on, he dies. How many cars will Mr. F be entitled to? 5 cars. Supposing that after the making of the will, the testator acquired 4,995 additional cars. How many cars will F be entitled to? 5 or 5,000? 5 cars. Okay? Applying the general rule. But supposing the testator says, I give F all of the cars which I have, as well as any other cars which I may hereafter acquire. Ibang usapan yon. It appears upon the face of the will that his intention is to give even the after acquired cars. Remember, however, that Article 793 applies only to legacies and devices. It does not apply to instituted heirs. Therefore, if the testator says in his will, he makes his will in 1985, I hereby give my entire estate to my friend F. And in 1985, when he made this will, his entire estate consisted of 5 cars. When he died 20 years later in 2005, his entire estate consisted of 5,000 cars. How many cars will his friend F be entitled to? 5,000. F, in that case, is not a mere legatee or devisee. F, in that case, is an instituted heir. And therefore, since he was given the entire estate, he is entitled to the entire estate consisting of 5,000 cars existing at the time of the testator's death. Okay. Next point. What is a will? You have a codal definition in Article 783. A will is an act whereby a person is permitted with the formalities prescribed by law to control to a certain extent the disposition of his estate to take effect after his death. From Article 783 and the following articles, we can deduce certain fundamental characteristics of a will. One is that it is a strictly personal act. This is one thing which each one of us would have to do personally. We cannot delegate the making of a will to our best friend, not even through an express special power of attorney. It cannot be accomplished through the instrumentality of an agent or attorney. Hindi pwedeng yung mayaman na testator sabihin, tawagan ng abogado, attorney, gawa mo ako ng will, o ano hong lalagyan natin dito. Ay, bahala ka na. Mas magaling ka naman sa akin. Hindi pwede yun. The testamentary disposition should come from the testator himself. Kailangan siya mismo magsabi, I want my house in Quezon City to go to so-and-so, I want this to go to so-and-so, etc. Okay? The testator, as a matter of fact, is even prohibited from making testamentary dispositions whose validity or compliance will depend upon the will of another person. I call your attention to Article 787, for example. The testator may not make a testamentary disposition in such way that another person will have the power to determine whether it shall be operative or not. As I always tell my students, I have a sneaking suspicion that when Article 787 was crafted by the legislators, they had henpecked husbands in mind who had been conditioned by a lifetime of submission to their wives to simply leave everything to their wives. Okay? Yung meron ako isang kausap sabi niya, sabi niya, basta lahat ng importanteng desisyon, sa akin yan. Oo, sabi ko, maniwala ko. Oo. Halimbawa, yung problema sa Afghanistan, whether or not sa Taliban kami o doon sa mga ibang forces doon, desisyon ko yan. Malaking importanteng bagay yan. Pero yung halimbawa, kung saan kami titira, ay, desisyon na ng asawa ko yan. Okay. Alright. So, hindi pwede yan. I cannot say, for example, in my last will and testament, I hereby give my house and lot or my farm in Bulacan to my brother B, provided my wife will agree. Hindi pwede. Okay. Prohibited by Article 787. Okay. The testamentary dispositions must come, and the disposition of the property must be decided upon by the testator himself. Okay. Having said that, yun ang mga kuwan, yung mga magagandang mga pang-segue. Having said that, all right? Or ang isa pang mga kuwan, at the end of the day, di ba? You notice, mga ini-interview sa mga kuwan, at the end of the day. Okay. Or isa pang paborito nga, as I speak. Okay? Ibig sabihin, at present, as I speak. Ganyan-ganyan. Okay? Parang tinanong si Mar Rojas doon sa, why is Corina not campaigning for you? Oh, no, she's really campaigning. As I speak, or as we speak, she's campaigning in Bulacan. Alright. From time to time, there are certain mga expressions na, which crop up. Okay? There was one time na paboritong expression ng mga tao yung at this moment in time. Okay. Which is a little bit redundant. Sabi mo, redundant yun di ba? Sabi mo lang, at this moment, or at this time. Pero at this moment in time, redundant. Okay? All right. So, having said that, you take note of the provisions of Article 786. However, so we're still talking of yung, sabi natin, the disposition of the properties must be decided upon by the testator himself. Okay. Under Article 786, the testator is permitted by the law to give a specific property or sums of money to a class or a cause. Okay? specific property or sums of money, he can give that in general to a specified class or cause. And under the same provision, he is allowed to delegate the actual distribution to a third person. Pwede sabihin ko sa aking will, I leave the amount of 100 million pesos, okay, for the street children of Metro Manila. Okay, 100 million. So, let's just assume that I have 100 million. Di naman kasalanang mangarap, di ba? So, if I have 100 million, sufficiente, the legitimes of my compulsories will not be impaired, then the 100 million will be given to the street children of Metro Manila. I can say in my will, I leave the distribution of that amount to my executor. So, yung executor ko na, magdidetermine, sino ba yung mga street children, siya na mag-distribute nun. That's permitted. But I cannot give my executor a blanket authority or a blank check. I cannot say, I authorize my executor to get from my estate as much as he may deem necessary and to distribute it to the street children. Hindi pwede yun. It must be specific property or sums of money. Okay? All right. The moment, however, the testator refers by name, pinangalanan niya. The moment he refers by name to the testamentary beneficiaries, forget about 786. One step backward, you apply 785. Okay? And under Article 785, the duration or efficacy of the designation of heirs, legatees, or devices, or the determination of the portions which they have to take, when referred to by name, cannot be delegated to a third person. Tandaan lang natin, in Article 786, the beneficiaries are a specified cause or class. In 785, the beneficiaries are specific named institutions or individuals. So, I cannot say in my will, I hereby bequeath the amount of 100 million pesos to Centro Escolar University, San Sebastian College, and University of Santo Tomas. And I leave it to my executor to determine how much out of the 100 million will be given to each of these institutions. Hindi pwede yun. Because I have referred by name to the beneficiaries, I am not allowed by Article 785 to leave to the discretion of a third person the duration or the efficacy of the designation or the determination of the portions which the named beneficiaries will get. Okay? 785. Next point. No matter how carefully a will may have been crafted, no matter how experienced the lawyer who drafted the will may be, there is always the possibility of an ambiguity in a will. Okay. There are two general types of ambiguity. The patent ambiguity and the latent ambiguity. Patent ambiguity is an ambiguity which is obvious, apparent from a mere reading of the testamentary provision. I give to 2 of my 5 brothers my house and lot in Quezon City. Oh, basa mo pa lang noon, alam mong malabo yan. Sino yun? Because the provision itself says he is giving the house and lot in Quezon City to 2 of his 5 brothers. But he did not even bother to name who these 2 brothers are. Okay. Pwede bang you apply the shotgun method? You give the property to all 5 brothers. At siguradong tatamaan yung intended beneficiaries. The answer is no. Why? Because whatever happens, the principal rule in testamentary succession is always the ascertainment of the intention of the testator. That is the guiding star in testamentary succession. And obviously, in that case, the testator did not intend to give that property to all 5 brothers. He intended to give it to only 2 of them. That's a case of patent or obvious ambiguity. What is the solution? Intrinsic evidence as well as extrinsic evidence, but excluding the oral declarations of the testator. Okay. Ano yung intrinsic evidence? Evidence found in the will itself. You read the other provisions of the will. For all you know, in another page of the will, baka may nakalagay doon, to my 2 brothers, Procopio and Tarpulano, I want you to take good care of my house and lot, which I am giving to you. Okay? I want my other relatives to know that the reason why I gave these 2 brothers that property of mine is because they were the ones who helped me a lot when I was still running for public office. Okay? They were able to mobilize voters for me. Ayun, solved. Intrinsic evidence. Evidence found in the will itself. Extrinsic evidence, pwede yan. But excluding the oral declarations of the testator. Hindi pwedeng during the contest as to the meaning of sino ba yung 2 brothers na yan. All 5 brothers will be presenting witnesses. Okay? Tigi-100 testigo sila. Brother number 1, 100 witnesses. Nadinigo namin yung testator during his last birthday na itong brother na ito ang sinasabi niya na binigyan niya ng property. The next brother will present another 100 witnesses. Sabi nung testator nung nakausap namin, ganito, ganyan. In other words, hindi pwede yan sabi-sabi. Okay? Basically, hearsay. And fundamentally dangerous and risky. Because as I always want to emphasize, at that point, the testator will be 6 feet below the ground. Okay? He's in no position to object. He's in no position to belie the false assertions of lying witnesses. That would have permanently sealed his lips. Sabi nga. So the law very wisely says, hindi pwede yung mga oral declarations. If it is not an oral declaration, alam mo, may sulat, pwede yan. My dear brothers, Tarpulano and Procopio, I want you to know that today I made my last will and testament. And in that will, I gave you my house and lot. Okay? Pwede yan. Alright. What about latent ambiguity? Ito yung ambiguity which is not obvious. Okay? Obvious ba? Sabihin. Kung obvious, patent. Pero kung hindi obvious, latent. Okay. Sabi ng testator, I give my first cousin, Jose Santos, my house and lot in Quezon City. Oh. Reading that provision, is it clear or not? But it's as clear as morning sunshine. Okay? He's giving his house and lot in Quezon City to his first cousin, Jose Santos. Paano kung after the death, 5 pala ang first cousin niya na pare-parehong pangalan, Jose Santos. Which is not an outright impossibility. Yeah? In some families, there are certain favorite names. The first, the second, the third, the fourth, etc. Among the Laurels, for example, hanggang Jose Laurel IV, alam ko meron. Paboritong pangalan niya ng mga Laurel, Jose. After the old man, President Jose P. Laurel. Okay. So, what now? Same solution. Intrinsic evidence, you read the other provisions, baka merong ibang provision doon which will clarify the ambiguity, or you may have to resort to extrinsic evidence. But then again, excluding the oral declarations of the testator. You give the words of a will their ordinary grammatical sense. Technical words, you give them their technical sense. Unless it is clear that the will was prepared by the testator all by his lonesome self, and that he used certain technical words without realizing the technical meaning of those technical words. General rule, as I mentioned a while ago, testacy is to to be preferred over intestacy. If there are two ways of interpreting a will, one will result in intestacy, you avoid that interpretation. You always try to have testacy. Okay? One last point before we call it a day. I promise that we will go a little, we can go, I think we have covered enough by way of aperitif. I just want to call your attention to Article 795. The validity of a will as to its form depends upon the law in force at the time of execution. If there are subsequent changes in the law, they will generally not affect the validity of the will. Okay? Exception. If the subsequent law provides for retroactivity. Exception to the exception, even if the subsequent law provides for retroactivity, if in the meantime, prior to the effectivity of the new law, the testator has died. Why? Because in that case, we go back to our favorite article, 777. Upon the death of the testator, successional rights would have been transmitted. These are already in the nature of vested rights. They cannot be impaired by a subsequent change in the law, even if the subsequent law provides for retroactivity. Okay? We'll take it up from there. So tomorrow we meet again. We start with testamentary capacity and intent.